Well, now, which of you wants to go first?
If I may, Ms. Dimitri has an application she would like to make, and
Yes.
she's free to make that. In the interim, we have been busy trying to put forward a possible order, which I hope has reached the court by this stage. If not, I can hand the order up. And the order is not the most elegant order in the history of drafting, but what it seeks to do is capture the court's concerns as expressed this morning and the parties' concerns as communicated to the court. Now, the order is largely agreed subject to important points. So subject to Ms. Dimitri's application, perhaps we can come back to that.
I'm so sorry to rise, and I mean no disrespect at all, but this is rather putting the cart before the horse, because I am seeking to persuade the court to hear the points now. And so,
well, we appreciate that. We know that's what you're trying to do.
Yes.
We've gathered that from what you've put in front of us. But,
yes.
We'd still like to know the simple thing, which is what is being suggested that we should do, and then we'll listen to you.
I'm grateful, my lady. So just to run through the order, paragraph 1, the adjournment, which I gather would be until October, same time estimate. 2, the critical event, the Commission will report upon the expiry of the 2-month deadline to the registry as to whether it is appealing. Then, to confer jurisdiction on the court, the appellant will make an application to vary the first instance order. And at the tail end of paragraph 3, you will see the point on leapfrogging, which we think is necessary. Then 4 and 5 are essentially mechanical. We will have to inform the court as to what happens next. 6 were obviously in the hands of the court, but it did occur to us that page-limited supplemental written submissions might be of assistance.
25 pages is not a very short page limit.
An opening bid.
Well, yes. Okay, we see the date which the court could offer, were this to be the situation, because we have to listen to Ms. Dimitri seeking to persuade, would be the 3 days beginning on the 7th of October.
Grateful. Emily, perhaps I can come back to the 2 sticking points following Mr. Dimitri's application.
I think we'd better hear Mr. Dimitri.
My lady, I'm sorry to interpose, but would it be convenient for the court to hear some further observations and reflections from the Commission before Ms. Dimitri makes her application, or should we wait to hear that first?
The trouble with all of that sort of thing is it all depends what you're going to say. So I think we'd better let Ms. Dimitri make her application.
My lady, I'm grateful. Before you kindly adjourned to allow us to take stock and make submissions on whether the court has jurisdiction to hear these proceedings now, there was, you will have seen, broad agreement between the parties that if it were possible to proceed now, then we should. And I made some brief submissions before the adjournment as to why it would be expedient for the court to do so if possible. We submit that the court can indeed proceed to hear the appeals now, and I'm going to make 3 submissions which are related. The first submission is that the relevant provisions under the Constitutional Reform Act give the court a very broad power to hear appeals, and I'm going to take the court in a moment to those provisions and make some brief submissions. The second point is that there are orders below. So if the court needs there to be live orders on which to hang these appeals, and I'm going to be submitting that you don't, but if you did, then there are orders below which are live, and the orders are the security order, which remains in force, and the costs order in respect of the stay against which we are appealing. And then the third submission I make is that in any event, these appeals raise a point of public importance which go beyond the parties' private rights. And on that basis too, the court is entitled to proceed to hear the appeals. Now, if I may elaborate on those submissions, but first of all, I would like to say this, that it's important to bear in mind the premise for my submissions is that Romania and the Commission have confirmed that if these appeals were to proceed, the arguments would be exactly the same. And so, to put it another way, if the Micula brothers proceeded to seek execution of the award, as they're now entitled to do, given that there is no extant Commission decision, then we've heard that they're likely to be faced with precisely the same arguments that have been raised in this appeal. But the premise for those arguments would not be, of course, that there's a Commission decision which is valid, which conflicts with execution of the award. It would be the argument based on sincere cooperation, which you've also seen fully expounded in the written cases. And so the argument would be that there is likely to be an appeal before the CJEU, and in those circumstances, there is a conflict or a potential conflict which the English courts should, as a matter of EU law, strive to avoid. So with that in mind, if I could ask the court to turn first to the Constitutional Reform Act of 2005, and I ask the court, of course the court is very familiar with these provisions, but I just ask the court to note 2 points, if I may. The first is that section 40, subsection 2, states in very broad terms that an appeal lies to the court from any order or judgment of the Court of Appeal in England and Wales in civil proceedings. So there doesn't need to be an extant order. An appeal can lie against a judgment. And when one looks also at subsection 5, you see the breadth of the court's power to determine any question necessary to be determined for the purposes of doing justice in an appeal to it under any enactment. And of course, that's the broad power that was relied on by this court in the Bank Mellat proceedings in a different context, but albeit it demonstrates the breadth of the power to operate a closed material procedure. So those are the statutory provisions governing jurisdiction. And I'm going to take the court briefly to 3 authorities in which the court refused, so the House of Lords declined to hear appeals between private parties on the basis that they were then academic. And the points that I seek to derive from these judgments, because obviously the outcome of the judgments doesn't assist me, but the points that I seek to derive are twofold. So the first is that the House of Lords in those cases approached the matter not as there being a bar to jurisdiction, because there was no live dispute, but decided that as a matter of discretion or proper exercise of the court's powers, they would decline to hear the proceedings. And I will respectfully submit that this case can be distinguished from those cases. And I will also rely on 2 of these authorities to demonstrate that where there is a live issue as to costs, that can constitute a list between the parties enabling the court to hear a substantive appeal. So those are the 2 points that I'm going to seek to derive from these authorities. So if the court could please turn first of all to the Sun Life Assurance Company case and turn to page 113. These authorities are all mercifully short. So page 113, you see the judgment of the speech of Viscount Simon, and you see there that he proposes that, in his opinion, the House should decline to hear this appeal on the ground that there is no issue before us to be decided between the parties. The difficulty is that the terms put on the appellants by the Court of Appeal are such as to make it a matter of complete indifference to the respondent, whether the appellants win or lose. The respondent will be in exactly the same position in either case. He has nothing to fight for because he has already got everything that he can possibly get. I do not think it would be a proper exercise of the authority which this House possesses to hear these appeals if it occupies time in this case in deciding an academic question, the answer to which cannot affect the respondent in any way. If the House undertook to do so, it would not be deciding an existing list between the parties who are before it, but would merely be expressing its view on a legal conundrum without in any way affecting the position between the parties. So the first point that I seek to derive from this is that if there is no longer any dispute between the parties, that does not bar the court as a matter of jurisdiction from determining an appeal. But it is obviously a factor which goes to the court's discretion as to whether or not it would be appropriate to hear an appeal. And in the circumstances of that case, the House of Lords held that it would not be appropriate because the matter was purely academic and could not affect the position between the parties. And we say not so here because the court has heard how these issues will continue to affect the positions of the parties going forward. And so, again, as I've indicated, we anticipate that if, as my clients are entitled to do, they proceed to apply for execution of this award, we will be met with exactly the same arguments. And so in those circumstances, determination of these arguments by the court is not such as it was in the Sun Life case as to not affect the position of the parties. Quite the contrary, that these issues will continue to affect the position of the parties. And therefore we say that the court should exercise the powers that it has to determine these appeals. My lady, my lords, the next authority is the Ainsbury and Millington case. And if I could ask you to turn to the judgment, well, it's Lord Bridge gave the speech and the other members of the House of Lords agreed with his speech. And you will see on page 380 that Sun Life Assurance was cited and discussed. And I want to take you to page 381 at letter B. In the instant case, neither party can have any interest at all in the outcome of the appeal. That's because, just pausing there, the action was all about the tenancy of premises which were argued to be unsuitable. And what happened before the proceedings came to appeal was that the tenancy had been terminated and the parties were now living in different accommodation. And so the issue really was academic. Their joint tenancy of property, which was the subject matter of the dispute, no longer exists. Thus, even if the House thought that the judge and the Court of Appeal had been wrong to decline jurisdiction, there would be no order which could now be made to give effect to that view. It has always been a fundamental feature of our judicial system that the courts decide disputes between the parties before them. They do not pronounce on abstract questions of law when there is no dispute to be resolved. Different considerations may arise in relation to what are called friendly actions, and conceivably in relation to proceedings instituted specifically as a test case. The instant case does not fall within either of those categories. Again, litigation may sometimes be properly continued for the sole purpose of resolving an issue as to costs when all other matters in dispute have been resolved. Realistically, counsel did not suggest that the possibility in this case of either party being ordered to pay the costs of the other, which in practice is so remote as to be negligible, could be regarded as affording a sufficient lis inter partes to keep the appeal alive. And so again, the propositions that I seek to derive from this authority are that the House of Lords approach the matter not as there being a bar to hearing, a jurisdictional bar to hearing the appeal, but it being a matter going to the courts, the proper exercise of the court's discretion. And we see that they envisaged various exceptions to the proposition that when a matter becomes academic, that the court should not exercise its powers to determine it. And we make 3 points on this. So the first point is that, for the reasons I've already given, and I won't labour, this is not academic because these points continue to affect the positions of the parties. The second point is that there is a costs order, And we're not in the situation that the parties were in the Ainsbury case, where the possibility of costs being enforced is so remote as to be negligible. Far from it. So there is a live costs order, and if a hook in the form of an order is required for the court to consider these proceedings, then that is ample, because in order to determine the cost dispute, then the court will need to take a view on the substantive merits of the argument. And the third submission that I seek to advance is that although this is not a test case, which was one of the exceptions envisaged there, it is nonetheless a case which raises a point of public importance going beyond the private rights of the parties. I'm going to make some brief submissions about that point, but before I do so, I would just like to take the court to the next authority, which is the Elders Pastoral case. Now, I need to caveat this slightly because it's an appeal to the Privy Council, and so I'm not relying on it to make submissions about the jurisdiction of the court, because that was covered by the New Zealand Appeals to the Privy Council order, and the court can see that at 1092 F to H. I rely on this for one proposition, which is that if the court turns to page 1094D, you see there the finding that in the present case the question is not academic, because if the appellant elders win, then the bank will be obliged to refund elders all the costs paid pursuant to the orders made by the New Zealand courts, and to pay the costs incurred by elders in the litigation and in the appeal. So that's an example of a dispute which had become substantively academic, but which was nonetheless entertained by the Privy Council because of the extant dispute on costs. Now, finally, I turn to the question, to the third part of my submissions, which turns on there being a point of public importance. This court will of course be very aware that in the context of public law, this court frequently does determine points which are academic, which nonetheless raise questions of public importance. In the time available, we provide just one example, but I think I don't really need to show the court authority for that proposition. It's the Rupiah case, and you'll see at paragraph 3, Lord Wilson there stating that Ms. Rupiah's appeal has recently become academic. There's then a lengthy explanation of why, and then at 7, the result is that the Home Secretary then granted to Ms. Rupiah all that she could have hoped to achieve in the present proceedings. Thought then turned to the utility of any further prosecution of the present appeal. In the event the court agreed with the parties that the appeal should proceed, the court agreed that it was of general importance for it to offer a definitive interpretation of the word precarious in the statute. Now, that's obviously in the context of a public law case, but I submit to the court that a similar, analogous reason for proceeding in the present case arises, and that relates to the point of public importance and public interest, which is the scope of the obligations of the United Kingdom under the ICSID Convention. Now, if I could ask the court briefly to turn to the first bundle of authorities and turn up the convention, which is behind tab 6. And I ask you to turn, first of all, to electronic page number 97. The court will no doubt have seen these provisions, but Article 54 requires each contracting state to recognise an award rendered pursuant to this convention as binding and enforce the pecuniary obligations. And the court will have seen that it's our submission in the cross appeal that what that means is that enforcement should be automatic. Now, the other provision that is relevant is, for my purposes now, is Article 69, which you'll find on page 101. And Article 69 imposes a general obligation on each contracting state, including, of course, its courts, to take such legislative or other measures as may be necessary for making the provisions of this convention effective. Now, my lady, my lords, may I just show you one of the things that we make of Article 69 in our written case. And I can do this very quickly by reference to our written case, which is in the core volume behind tab 8, and it's electronic page 4589. And the paragraph that I wish to draw the court's attention to is paragraph 139C. And what we argue there, this relates to the obligations imposed on the United Kingdom by Article 69 of the Convention that I just took the court to. And what we say there is that imagine if in the 1966 Act, Parliament had provided that no award was to be recognised or enforced if contrary to domestic public policy. Well, we say that that would represent a plain breach of Article 69 of the Convention. And we say that by analogy, what the Court of Appeal has done in this case by ordering the stay represents an analogous breach of Article 69, because what the Court of Appeal has done is determined that where an award falls to be enforced under the ICSID Convention, and there is a conflicting provision of EU law, the correct approach is to stay enforcement in circumstances where we say the proper construction of the ICSID Convention is that enforcement should be automatic. And so you see how we say that for the reasons given above, the effect of the Court of Appeal's order is to create that type of exception, and we say that that's a breach of Article 69 of the ICSID Convention. So where does that take us? Well, in my respectful submission, it takes us here, which is that the court undoubtedly has jurisdiction under the 2005 Act to determine appeals against judgments. And the effect of the Court of Appeal's judgment is to create such an exception, which we say is a breach of Article 69 of the Convention. And that is a point which goes far beyond the private rights of the parties to this dispute, but is a judgment which is apt to be applied in any case, and there are many cases in which ICSID awards are said to conflict with EU law. And so by analogy to the position in public law cases where this court decides that even if a point is academic, there is a public interest in determining it, we say that that applies here for that reason. But of course, my position is a fortiori, because we say the point is not academic, because all of these arguments will be, it's anticipated, in the very immediate future, continue to affect the parties' positions. So unless the court has any questions, those are my submissions on this point.
Yes, we heard you. Thank you.
Lady, just a couple of brief points. Just to emphasise, in relation to Section 40, subsection 5 of the Constitutional Reform Act 2005, that has perhaps particular significance in the provision made in subsection 5 that the court has power to determine any question necessary to be determined for the purposes of doing justice in an appeal to it under any enactment. And obviously that is in a sense, a prisoner to subsection 2, to which my learned friends already averted. But it is important in this sense that the starting position before Mr. Justice Blair in relation to our own application for security is that it should be refused, because the court had no jurisdiction at all to order security. And that was paragraph 2 of our skeleton argument before Mr. Justice Blair. On the same basis as we argue that a stay too should be refused. So it is, in our respectful submission, not possible to resolve the issues on the cross appeal without effectively resolving the issues on the appeal. So even if one is pressed to the ascetic point of saying, is there also an order on the cross appeal? we would respectfully say, well, even if there isn't, and even if the cost wasn't a sufficient order, nonetheless, if there was a proper foundation on the appeal, then the court could find support for determining those matters for the purposes of our cross-appeal in section 40, subsection 5. The second point I wish to make was simply this, that in a number of the cases where the court has considered whether or not to determine a matter of public interest, that the availability of the remedy of the declaration in relation to matters which may affect a party, but where there may be no instant order or no instant matter to be corrected, is a very important one, particularly, we respectfully submit, in a case involving these issues of public policy. And my lady, my lords, I would respectfully submit that although this has not been identified as a test case in the sense that that's why it's brought, it is regarded not just in this jurisdiction as just that, because it goes to the question of the availability of the public policy exception, which was expressly ruled out in the ICSID Convention itself. And so what one has here is a confluence of two important factors. The matters in issue in the appeal continue to affect the private rights of the parties before the court, and it raises not just a point of public importance in the abstract, but as Lady Justice Arden observed at paragraph 173 of the Court of Appeal's judgment, which the court will find in MS 4676, which is in tab 10, is the Court of, I'm only citing one example, but the second sentence of paragraph 173 says, however, the question of the UK's obligation to enforce the award goes directly to the position of this court as an organ of the state. So this is not the general sense in which people come before this court and say it's a point of public importance. This actually affects the standing of the Court of Appeal as an organ of the state in complying with the obligations to which my learned friend has already referred. The final point to amplify is that if the court could just quickly look also back in the primary authorities bundle, number 1, at the convention itself in tab 6, on page 97, learned friend Mr. Demetriou referred to Article 54, but the court should not lose sight of the provision in Article 53.1, which refers up to the complete code in section 5 of the convention. And it says the award shall be binding on the parties and shall not be subject to any appeal or to any other remedy except those provided for in this convention. And that's a reference up to the complete code for the basis upon which there can be an annulment or revision application under section 5. And that is another facet of the convention which the United Kingdom is obliged to give effect to under Article 69 of the convention, to which the learned friend has already referred. And that is the deliberate policy choice in the convention to exclude the public policy exception, which we find available in the New York Convention and under the 96 Act, and is not available under the ICSID Convention or the 1966 Act. And that brings one last point, which is that the result of this would be to leave the law in a state in which a decision of the Court of Appeal in relation to the ICSID Convention would appear to be out of step with the decision of the Supreme Court in IPCO in relation to the New York Convention. So in IPCO, what the Supreme Court determined was there was a complete code in the New York Convention to which the 96 Act gave effect, and that the court could not, by the back door of general CPR powers, subvert the scheme of the complete code in the New York Convention. And in this case, we respectfully say that the issue squarely before this court is that there is clearly a complete code in the ICSID Convention, but at the moment we have a Court of Appeal decision which didn't even refer to IPCO, even though that was cited to the Court of Appeal, and leaves the position on the ICSID Convention starkly out of step with the view taken by the Supreme Court in IPCO. So unless I can assist the court any further, those are supplementary submissions which we might make.
Thank you, Mr. Green. Thank you.
Yeah, a handful of points. First, the court's decision, of course, is discretionary. And in that context, if I can refer the court to paragraph 268 of the Court of Appeal's judgment. Court 10, Appendix 1, internal page 4697.
So who is this?
Lord Justice Leggett. So he picks up on the points alluded to by my friends, and he says these are very difficult and sensitive questions. It would be wrong even to embark on addressing those questions unless there is plainly no alternative to doing so, and as a last resort. Both the UK law and EU law have various methods of avoiding conflict, and those methods need to be exhausted before court entertains the possibility that it is not required by Section 2.1 to apply EU law. And the quotation from Lord Mance, again on the same theme. So in my submission, while this is a question of jurisdiction, an important factor going to discretion is that if there is a possibility that a conflict evaporates because, for example, there is no appeal by the Commission, or as is increasingly possible, the United Kingdom exits the European Union shortly, those are discretionary matters which feed into the court's discretion, and they're important matters. So in other words, if a conflict can possibly be avoided, that is a legitimate and important exercise of discretion. Second, reference was made to the question of costs. In my submission, this proves too much. In every case, there will be questions of costs, and this is not a case in which a point of law is taken on costs. It is simply costs at large. So that cannot be a sufficient basis on its own. Third, the delay is relatively short, and indeed, when one factors in the summer vacation, it is not self-evident that the delay on a net basis will be much, if anything, and that is a factor. Fourth, Ms. Dimitri referred to the orders below. What she didn't show the court is where in the context of the stay, the orders below give the court jurisdiction. There was a reference to the security order, but that is not the order she needs to found jurisdiction. She needs jurisdiction on a stay. And fifth and finally, on public interest, a couple of discrete points. First of all, Mr. Dimitri's and Mr. Green's submissions, they effectively invite the court to prejudge ground one of the cross appeal. So essentially, what we heard was the greatest hits of their ground one cross appeal arguments. It would be quite unfair and prejudicial in my submission to Romania for those to be judged on an interlocutory or on the hoof basis. Those are matters for the appeal proper. Second, much reference was made to public policy, but again, Romania's response to the cross appeal is that a temporary stay is a case management matter. It is not an exercise of public policy. And to decide that point either way at this stage involves a prejudicial assault on the cross appeal and the response to that. And finally, the suggestion that the court, having adjourned for lack of jurisdiction for a handful of months, would lead to the United Kingdom being hauled before the ICJ, with respect, is exaggeration.
I don't remember that being said.
Well, Article 69 was referred to, that there would in this short period be a significant public interest in the United Kingdom's obligations being clarified. And in my submission, that is somewhat exaggerated.
Is this an appropriate point for you to say whatever it is you wanted to say, Mr. Khan, or is it not the right time?
My lady, I'm very grateful for the opportunity. I shall be extremely brief. Despite the court affording us the opportunity of the adjournment, I'm afraid, as I indicated this morning, I can't take the matter any further as regards the possibility of an appeal. But it's important to bear in mind that the Commission has two roles in the present circumstance. One as defendant to the action that was brought before the General Court, where it has to contemplate the possibility of an appeal. The other role, though, which it's worth drawing attention to, is that of a competition authority. As a matter of general principles of EU administrative law, the annulment of a decision adopted at the end of an investigation means that the investigation is reopened at the point before the error made was committed. That means that we have an open investigation which, in the light of today's judgment, has not yet been validly closed. This is very much linked with the question of the appeal, because how the Commission might validly close its investigation is inextricably tied up with the question of whether it appeals and what is the scope of that appeal. But even if we take the judgment as it stands, although I won't disguise the fact that the judgment is a defeat for the Commission, and the operative part of the judgment is the setting aside of the decision, as has been submitted in the main case, the operative part has to be read in the light of the reasoning behind it. And if one looks at that, then it's far from clear that the decision represents some absolute blow to the possibility of the Commission ever taking action with respect to the arbitral award. If I can just briefly take the court to the General Court's judgment. For example, in paragraph 79, the court holds that because the state aid rules of the treaty, Articles 107 and 108, were not applicable in Romania before its accession, the Commission could not exercise the powers conferred on it by Article 108 and could not in particular censure the incentives laid down by the EGO aid scheme for the period predating that accession. And you find that same caveat further on in the judgment, for example, paragraph 90, where the court holds that the amounts granted as compensation for the period predating Romania's accession cannot constitute state aid within the meaning of EU law. But then in paragraph 91, it says furthermore, as regards the amounts granted as compensation for the period subsequent to Romania's accession, namely the period from the 1st of January to the 1st of April 2009, even assuming that the payment of compensation relating to that period could be classified as incompatible aid, given that the Commission did not draw a distinction between the periods of compensation for the damage suffered by the applicants before or after accession, the Commission has in any event exceeded its powers in the area of state aid review. And you find a similar approach in the judgment relating to the second ground, which is addressed in the judgment, paragraphs 105 and 106, where the court holds at 105 the compensation for the withdrawal of the EGO scheme, at least in respect of the amounts relating to the period from 22nd of February 2005 to the 1st of January 2007, cannot be regarded as compensation for the withdrawal of aid, which is unlawful or incompatible with EU law. And then in 106, insofar as EU law is not applicable to the compensation for the withdrawal of the EGO, at least in respect of the period predating accession, the applicants may, at least for that period, rely on the judgment in asterisk, which holds that compensation is not to be treated as state aid if it is purely compensation. Thus, my lady, my lords, the judgment does not rule out the Commission having competence to find aid for the post-accession period. And so the wider position is one where, although there is no extant order for the court to hear an appeal from, because Mr. Justice Blair's order was predicated on there being a decision in existence, and the present circumstances therefore don't match up with the order under appeal before the court. We don't have a decision, but we do have a reopening of the investigation. And it's of some practical importance, since the very fact of there being an open investigation, we say, triggers the Deutsche Lufthansa obligations of sincere cooperation. The court will have noticed that Deutsche Lufthansa is debated in the context of the written cases on the premise that the decision is binding, but Deutsche Lufthansa has a wider import. If I could briefly take the court to Deutsche Lufthansa.
I'm sorry,
I'm sorry, no.
before we go to that, could I just stick with the present point for the moment? That the point you've made is one that had occurred to me also, that it may be the Commission could retake the decision, confine it to a certain element of the aid, and it would then be a valid decision. I wondered about paragraph 78.
Of the judgment.
Yes. It is one of these judgments that looks as if there have been different hands in different parts of it. In paragraph 78, the court says it must be concluded that the applicant's right to receive the compensation at issue arose and began to take effect at the time when Romania repealed EGO 24, that's to say before Romania's accession, and therefore at the time that that right was conferred on the applicants. The arbitral award is simply a recognition of that right, and the payments made in 2014 merely represent the enforcement of that right which arose in 2005. That passage seemed to treat the aid as a whole as something the right to which had vested before accession.
Indeed, although that is then immediately qualified, it seems, by what the court says in paragraph 79, and then repeatedly later on in the concluding sections of its findings, it always enters this caveat about the distinction possibly to be drawn between pre- and post-accession aid. There's also paragraph 108, which is worth alighting on, where the court said that as the compensation issue covered at least in part a period predating accession, and as the Commission did not draw a distinction among the amounts to be recovered. The problem the Commission was confronted with, my Lord, is that the award did not distinguish between aid amounts that would have been paid before and after accession, and the way in which the arbitral tribunal calculated the compensation did not seem to recognise any distinction between pre- and post-accession periods, or calculate the compensation by reference to any particular period. And the Commission took the award as a single award and didn't break it down. The hint given in this judgment is that if the Commission had broken it down between pre-accession and post-accession, then the result might have been different.
So the options in front of the Commission aren't simply does it appeal or does it not appeal. It might retake the decision to a different effect.
My Lord, yes, if the Commission wanted to retake essentially the very same decision as has just been annulled, it would be necessary to contest successfully before the Court of Justice the findings made in this judgment. If, on the other hand, the Commission were content to accept its defeat in relation to pre-accession aid and to narrow the focus of the investigation in order to close it a second time, then it's conceivable that no appeal would be necessary on that basis. Oh, yes. And Thus, we have a subsisting open investigation which the Commission has a duty to close, and that is precisely the situation that the court was considering in Deutsche Lufthansa. That's a case where Frankfurt-Hahn Airport was a loss-making airport. If I just briefly take the court to judgment, I'm going to dwell on it at length, but just to recall the facts, you'll see at paragraph 11 of the judgment, it's in volume 5 at tab 74. The case arose out of...
Page
Could you give the
reference.
electronic page number?
I'm sorry, my lord. The case begins at page 1254. And it's in bundle 5.
And what are you wanting to refer us to?
What I'm seeking to do, my lady, is just draw your
No,
attention...
could you have the page that you want us to look at?
Well, the first page to look at is at page 1257,
Thank you.
where at paragraph 11, it's noted that Frankfurt-Hahn Airport had generated considerable losses. And at paragraph 14, further down that page, this was the subject of complaint by Lufthansa because Frankfurt-Hahn Airport was largely used by Ryanair, a rival. So Lufthansa claimed that Frankfurt-Hahn Airport was a beneficiary of aid. And then on the next page, 1258, paragraph 16, whilst litigation was going on in Germany about that, the Commission started a formal investigation, and then the National Court referred the questions which you see at paragraph 18, again on page 1258, and the court, in addressing those questions in the context, as I emphasize, of what was no more than an open investigation that had been started by the Commission but which hadn't been concluded by a decision, then if we go to page 1260 and paragraph 31, there's a reminder of the standstill obligation of Article 108, paragraph 3, and the task of national courts in that respect. And then, if we turn over to page 1261, you then have paragraph 37, the court saying that while the assessments carried out in the decision to initiate the formal examination procedure are indeed preliminary in nature, that does not mean that the decision lacks legal effects. And then there is the much quoted dictum in paragraphs 39 and 40, again on that page, which are quoted in the second to fifth claimant's written case at paragraph 44. So, my lady, my lords, indeed, on the logic of the Court of Appeal, the existence of an open investigation rather than a final decision, which no longer exists, is of somewhat greater significance as a constraint on what a national court can do. So, in conclusion, it's not the Commission's position that enforcement can now proceed unconstrained, but we recognise that there is a formal constraint on hearing the appeal. Although the appeal was mounted on an assumption of the validity of the decision, notwithstanding that the Miculas were challenging that decision before the General Court, the fact of the annulment of the decision means that to hear the appeal now would mean that some issues perhaps simply could not be ventilated. For example, there's much debate about the meaning of recital 161 of the decision. Well, we don't have a recital 161 of the decision any longer to argue about. So, my lady, my lords, I just wanted to emphasize that the annulment of the decision and the possibility of an appeal against it is only one facet of the obligation not to give rise to a conflict with a possible final decision by the Commission on a state aid matter. Unless I can help the court any further, those are the observations I would make.
Thank you very much, Mr.
Thank you, my lady.
4 brief points by way of reply, if I may. So the first point is that having said that Romania were content to proceed today before the adjournment, they now seem to have changed their mind, and Mr. O'Donoghue was arguing that, that the court should not proceed now.
Well, we're not privy to the exchanges that there were between the parties last week. We don't know what you were arguing about.
My lady, no, I referred only to what he said before the short adjournment this morning. I wasn't intending to refer to anything, any other exchanges. There haven't been on this point. But I'm not seeking to make a forensic point about that, but merely to say that this afternoon, the only reason that was really given by Mr. O'Donoghue for saying that it would be expedient to wait was by reference to the judgment of Lord Justice Leggett, where Lord Justice Leggett said, well, if a conflict can be avoided by waiting, then we should do so. Now, of course, the first point to make is that we say that that's the wrong approach in law, so the court shouldn't assume that that's correct. But the second point to make is, well, on what basis does Romania think that a conflict might be avoided? Well, the only basis given by Mr. O'Donoghue was that an appeal might not be brought by the Commission. And you heard him this morning say precisely the opposite, that in fact everyone's expecting there to be appeals. And so we say that that point should be given very little weight. The next point he made is that our submissions assumed that our grounds on the cross appeal were well-founded, but with respect, they don't. They assume that our arguments on the cross appeal are arguable, and on that basis, there is an argument, it is arguably correct, and I don't need to put it any higher, that the UK is currently, because of the Court of Appeal's judgment, in breach of its international law obligations. And I don't need to say that it's likely that another signatory state will commence an ICJ action before October. It's sufficient to say that there is a public interest in remedying that potential breach of international law that arises now and not delaying further. The third point that Mr. O'Donoghue made is that our reliance on the costs order proves too much, because he says, well, in many cases there'll be costs orders, and that can't be enough. Now, I wasn't seeking, lest it was not clear, I wasn't seeking to say to the court that the costs order in itself is the only consideration that weighs, that the court should take account of. The way I put it to the court is that there is, if the court considers that it's necessary to have an extant order, and we say not because of the 2005 Act, which permits appeals against orders or judgments, but if the court thinks there needs to be an order, well, there is an order. Now, we're not seeking to say, well, that in itself is sufficient reason to proceed with the appeal now. But what we do say is that there are other reasons, substantive reasons, for proceeding with the appeal now. The first is the point I've just made about the arguable breach of international law. And the second point is that all of these substantive issues between the parties will continue being substantive issues between the parties with more or less immediate effect. And so the points are not academic, far from it. They continue to affect the parties' positions. The fourth point that I wish to make relates to the submissions just made by Mr. Khan. Now, plainly the Commission will have to decide whether or not it would be consistent with the General Court's judgment to reach some other decision finding that part of the award constitutes state aid, and that's for the Commission to decide in the first instance. However, the fact that the arguments he makes about the principle of sincere cooperation arising based on Deutsche Lufthansa are arguments in our favour on this particular issue of whether or not the appeal should be heard now, because what they demonstrate is that the principle of sincere cooperation continues to be relied on.
Yes.
So, my lady, my lords, those are my submissions in reply. I do have some discrete submissions on the order, but I anticipate that you won't want to hear those now. But if I'm wrong, I'm happy to make them now while I'm on my feet, if you prefer.
Shall we go and decide what we're going to do?
Might have.
Well, yes. You're acting as Mr. Michu as junior.
Apparently so.
Yes.
Lady, just a couple of very quick points. It is right for the court to have in mind not only the Commission's position in relation to the continuation of the obligation of sincere cooperation, but also a minor point of correction in relation to something Mr. O'Donoghue said, which is in relation to Article 56 of the Statute of the Court of Justice, which actually provides that a member state, any member state, may intervene, may appeal, even if they didn't intervene in the general court proceedings below. So in fact, there could be an appeal by Romania or any other state. So Spain, for example, was a participant in that state. That's one short point of background. The other points my learned friend has covered, save my Lord Reid's point in relation to paragraph 78. And I would respectfully just identify that, in fact, if one looks at paragraph 91 of the decision, it hints at 2 points which I'd like to make. It's paragraph 91, line 3, and it's the words, even assuming that the payment of compensation relating to that period could be classified as incompatible state aid, given that the Commission did not draw a distinction between the periods.
Well,
So
we'd already looked at that.
my lady, yes. What that observation hints at is the terms in which the Europe Agreement was expressed, number one, which is in, if I can ask very briefly, just to look at Bundle 2, Authorities Bundle 2, at it's at tab 20, and the electronic bundle page number is 317. So this is the Europe Agreement to which Romania was a party and effectively the EU was a party. And Article 74 provided for investment, promotion and protection. And under Article 74(2), the particular aims of cooperation shall be, and there's a list there that begins with, for Romania to establish and improve a legal framework that favours and protects investment, and then conclusion by member states Romania of agreements of promotion and protection of investment, and then the fourth point, to bring about better investment protection. And it was in the context of the EU having been a party to the Europe Agreement, under which the bilateral investment treaty was entered into, that the case before the International Arbitral Tribunal involved not only a question of the nature of the incentive scheme of EGO 24, which was conferred, but also the availability to Romania prior to accession to have taken any number of the following options. One, to negotiate, as Poland did, the grandfathering in of aid as permissible. Two, to reframe or adjust the aid to characterise it in the same benefit, financial benefit, in a manner that would have been more acceptable to the Commission's preferences. Or three, to pay compensation to the Miculas and their companies prior to accession, all of which would have been available to Romania as the party to the bilateral investment treaty. So I just wanted to give the court, and my Lord Reid in particular, that perspective at what that reference in paragraph 91 might be hinting at.
Is Article 64 of the Europe Agreement also relevant in this context? That's 315.
Well, my lord, it is, but as your lordship knows, the position in relation to that was that the situation in Romania, as now reflected in the decision of the General Court this morning, was a matter for Romanian law. And what in fact the Miculas had done was to invest in Romania, the economic circumstances of which might have justified, even under EU rules, state aid being granted on a regional basis, and within Romania in a particularly deprived area. So
Yes,
your Lordship's right.
That's the reference to what used to be Article 92.3a.
Your Lordship's quite right. So the point about it was there was a perfectly reasonable basis upon which to think this was perfectly reasonable aid. And the disputed decision of the nascent competition commission in Romania didn't even refer to this particular aid. It referred to meat and other things and didn't consider justification. So that's why the Romanian government overturned it. So your Lordship's right that it's relevant, but in fact it was a matter of Romanian law, and Romanian law held it to be lawful. And that's the footing on which it was decided.
It's not a question for today, but when I read this Europe agreement, I did wonder what was the basis of the European Commission's intervention, what was their power to intervene as to the legality of this agreement before accession.
Your Lordship's right to wonder that, because not only did they not have one, but they did actually have powers under the Europe agreement to address anything that they disagreed with and didn't exercise them.
Through the Association Council?
My Lord, yes.
Yes.
And they didn't exercise them.
Yes,
So
precisely.
that's probably further than we need to take it for
No,
today.
I just wanted to clarify the position on that. Thank you.
Well, thank you all. We had better now adjourn and have another little chat. We'll be back as soon as we possibly can. Well, we have decided that we are going to adjourn the case until the 7th of October, so 7th, 8th and 9th of October. We may or may not provide some written reasons for our thinking behind that, but I suppose I should make it clear that we are not necessarily convinced that it's a matter of discretion rather than jurisdiction, but if it is a matter of discretion, we have taken everything that everybody's said into account and decided that for a variety of reasons it's sensible to exercise our discretion in that manner. Looking at the draft order that was handed up earlier, possibly, Mr. O'Donoghue, you said that most of it was agreed on the basis that we were going to adjourn, which of course was not agreed. So there are various amendments that we want to propose to it. Should we do that and then give you a very short amount of time to disagree with us? Well, we insert the date into paragraph 1. The Commission can let everybody know before the 2nd of September. That's giving you far too much time. You will have made up your mind what you want to do by the deadline. We believe that it would be realistic for you to let everybody know by the 20th of August. We therefore think that it would be reasonable for Romania to take action in consequence, or any action in consequence, within 7 days of that, because again, Romania will have worked out what its options are because we realise there are at least 3 things that the Commission could decide, if not more, but Romania will no doubt have worked out. So 27th of August. So the timetable for the, well, yes, again, and of course notifying the registrar whether all of you should notify this court what you intend to do as a result by the 27th of August. Then that 21 days before the Supreme Court hearing seems reasonable enough to exchange and file supplemental written cases. We have been concerned to try and achieve some sort of both economy and equity. So we thought that 25 pages each was rather too much, given that one assumes that you're going to maintain your legal arguments and it's really an updating in the light of whatever the events have been that is required. We think that 15 pages to Romania and 15 pages to the Commission and only 15 pages to the all the respondents looks a little unfair, given the identity of interest, at least to date, between the Commission and Romania. And so we would tentatively propose 10 pages each to Romania and the Commission, and 15 pages to the Micula, is that how it's pronounced? Micula parties. Will that do?
Yes, we do. The only point I would note on those changes are that you've asked us all to explain to the court what we're going to do on the 27th of August, but I apprehend that my clients won't know what they're going to do until
they know what Romania is going to do.
And so
yes.
I would ask for a few more days after that for
Yes.
us to indicate.
Yes, I can see the point of that. Romania can make both of its decisions on the 27th of August, but it would make sense to give you until, 7 days after that?
7 days after that.
Yep.
The other point I'd like to raise doesn't arise from anything that the court has indicated, but relates to the recital that Romania has drafted. And you see the second recital provides for us to agree not to seek execution on the basis of the award pending determination of this appeal. And we don't see that that's appropriate, given that the Commission decision has been annulled. So we're not, subject to the court's views, we're not prepared to agree that.
No, it would be a realistic thing. You would take a realistic view as to what would happen if you did, but that's, for you, is what you're saying.
Precisely.
Yeah.
Yes.
I would delete both of the second and the third. We don't tend to go in for that sort of thing in orders of this nature in this court. And to the extent that we've imposed it upon you, because of course you weren't agreeing, I'm not sure that it's appropriate to call it a consent order.
My lady, yes, the other issue, which doesn't arise from this draft, but really arises from the logic of the court's decision to wait, is that, of course, the premise for the court's decision is that there is now no Commission decision, it's been annulled. And on that basis, it seems to us that the Supreme Court's stay of the security order should also be lifted, because there is now no bar as a matter of EU law to security being paid. So that's the further additional point that I wish to raise at this stage. And those are the only points I have. Mr. Green may have some.
If there's no stay, how can there be security?
That is the logic.
The security stay is not dependent on the security order made by the Court of Appeal.
It says that, it doesn't say that,
it doesn't
but
say, yes.
in reality it is dependent.
Well, my lady, those you've heard what I've said. That's
Yes. Well, that was the view that we took when we were...
Yes, I mean, if Mr. O'Donoghue were to apply for the order to be discharged, the security order, there would be no answer to that, would there? So long as there's no stay in place.
Yes, my lord. May I put it this way? So, if one supposes that my clients were to decide, as they're entitled to do, to proceed to execute, to ask the court to execute the award. And we were faced then with the same arguments that we've been facing up to now. And Romania were to seek a stay, a continuation of the stay, such that we could not execute. Then in my respectful submission, then the security would be relevant. And the premise for the court not hearing the appeal now is that there is no clash between the security order and EU law. And so whilst of course we understand that we wouldn't be seeking execution of the award and security at the same time, because one is the alternative to the other, and we fully understand that, we do respectfully submit that if we were to proceed to ask for execution and be stymied because of these arguments, which we anticipate would be the case, then we should have the option at least of considering whether to enforce the security
Well, we're
order.
not going to decide that. That's a matter of what happens next.
Well, my lady, save that the security order, so the Court of Appeal did find that it was appropriate to order security, and that's been stayed by this court pending determination of the appeal, which is now, will happen later than we anticipated. And so my submission is that on the logic of the court's adjournment, it should also lift the stay of the security order.
You've got somebody nudging you.
Yes, let me just see what Mr. Leith has said. Yes, well, I think Mr. Leith is making the point that I was perhaps not making very clearly. He's making it more clearly, which is that essentially we wouldn't be seeking to do both at the same time. But if the Supreme Court lifted the stay on the security order, then in a sense all options would be available to the commercial court. Whereas as things stand, we're liable to proceed, if my clients chose to do so, to proceed to apply for execution of the award. And we may well be faced with a barrier in relation to that. And so we say that that it would be sensible for the stay of the security order to be lifted, such that the commercial court has the option instead of ordering security to mitigate the prejudice of the...
Oh, Mr. Green's got something to say.
Learned Friends Arthur Junior, my lady. Could I just invite the court just very briefly on this point? I can see it's a slightly awkward point in relation to lifting the stay. It is quite important to see what the paragraph says that the stay is on. And it's at 4633 in the core volume at tab 10.
Always a good idea to look at the actual order you're discussing.
And the wording was rather carefully chosen by the Court of Appeal because of the potential consequences.
Could you just give me the...
I'm so sorry, my lady. It's 4633. And it's paragraph 3 of the order. And the order was quite carefully crafted with an unusual ending. It was the respondent shall provide security in the amount of 150 million, etc. And then at the end, an appropriate form within 28 days of this order, unless the commercial court otherwise directs. So the effect of lifting the stay would be that there's then 28 days for Romania to invite the commercial court to direct otherwise, and that would allow the commercial court to be re-seized, as it were, of the question of whether there were circumstances in which that requirement of security should continue in the light of the facts made apparent to the commercial court at that stage. And that's not necessarily as odd as a situation that would prevail if that were not the position. So what one's effectively doing is giving the commercial court control back of that order in these proceedings.
Now, Mr. O'Donoghue is going to say something about that.
Well, I do reiterate the point. The logic of the order imposed by this court is that the stay and the security, in a practical sense, go hand in glove. And logically, no stay for now, no security. But we are concerned about the prospect of the court making essentially a contingent order. And in my submission, it would be much better that if and when something concrete crystallizes, that at that stage, in the light of the then known facts, the Miculas could make whatever application they consider appropriate. We do have concerns about an order being made at large, essentially in the abstract, without regard to the underlying realities.
Well, the view that we were provisionally taking in discussion between us was that your draft order contains liberty to apply, so that if it became appropriate for the Micula parties to apply to this court for us to lift the stay, then they could come and explain, and we can do things quickly if required. That was our view about that. So, does that mean we have completed the arguments for today? Well, we shall look forward to seeing you all on the 7th of October.